Hello, dear all. We start today our fourth webinar from the Legal English webinar series. And today the topic of our class is dedicated to language of contract law, enforcement mechanism of arbitration clauses. And I would like to introduce you again our teacher, Professor Dän Slоун, who is going to speak today. As he speaks, you will be able to vote on some of the questions that he asks. The links to the voting are on our website. Also, they are in chat on YouTube that I'm going to post it in a second, and also they're on Telegram channel that we have. If you'd like to, you can go there and vote while you watch the class today. Also, you can ask your questions in writing, and when we have the breaks throughout the webinar, I will be asking these questions on your behalf to Professor Slоун. So, Daniel, I'm giving the floor to you.
All right. Well, thank you very much, Sophia, and welcome everyone. I'm in California, as you can see behind me today. Very beautiful here. And we are on our spring break from university, so it's a great time of the year for us here. So today we have a different topic. We've spoken about contracts and contract clauses, and today we're going to be talking about the ADR, which is alternative dispute resolution, and some of the issues that are really interesting in regards to that. Let me go ahead and share my screen here. In presenting. There we go. Does this look okay, Sophia?
Yes, absolutely perfect.
Okay, great. So here we are, ADR enforcement. So there's some issues that I wanted to talk to you about with ADR, and most of you are probably familiar with it. The language of contract drafting, enforcement mechanism of arbitration clauses. The last couple of weeks, we've spoken about different parts of the language and the clauses that we use in order to better refine how to write the clauses and how to place them in the contract. And I understand there's some questions for me this time. We'll be looking at those, and we're going to be looking at something that's very interesting, which is enforcement. How do we enforce the contract, and what kind of clauses are necessary there in order to do that? So we're going to be looking at that. There's my picture I took yesterday here in California. Just want to show off what it looks like here in beautiful California. Monterey, some of you may have been here before. A very beautiful area of the world. Pebble Beach, if some of you are golfers. Very nice. Okay, so we have our QR code, and that was sent out by Sophia earlier. Again, I like to point this out, that in drafting a contract, you should always bear these following principles in mind. Be conversant with the party's wishes, use a checklist of clauses that relate to the subject and of the contract, and be precise in the words, the choice of words. Use several sample contracts to establish the format of the agreement. And those are always extremely good to use, even in ADR. Doesn't matter which type of contract you're going to use. And here's a good quote by Sandra Day O'Connor, one of our Supreme Court justices. The courts of this country should not be the places where resolution of disputes begins. They should be the places where the disputes end after alternative methods of resolving disputes have been considered and tried. And that goes very well with what we're discussing here today in terms of alternative dispute resolution and the types of activities that happen outside the courtroom. Down in Malibu, it's a little further south of where I am today, is where Pepperdine University is and where the law school is. And we have a great program there in LLM in dispute resolution. And that's a lot of people come here from all over the world in order to learn how to better prepare themselves for handling disputes and commercial arbitration, mediation arbitration. So what is dispute resolution? Just to touch on these very briefly, involves bringing two or more discordant parties to clear understanding wherein their differences are ironed out. They resolve them. It points out every technique applied for settling dispute between entities. And there's a whole host of things, maybe some of them you hadn't thought of, or maybe you don't use in your particular legal system, but obviously the first one would be avoidance, negotiation, early neutral expert evaluation, mediation, an ombudsperson, a peer review panel, conciliation, a kind of a hybrid model between mediation and arbitration, concilio arbitration, another hybrid model, judicial dispute resolution, arbitration, tribunal, and litigation. So there's quite a range of topics that could fit into the ADR model. And I'm not sure how many of those you use in your system, but it's quite extensive. So very important is whenever we're talking about ADR is how to prepare for this in advance. And so advanced thought should be given to the types of people who would best resolve a dispute likely to arise under the particular contract and an agreement in which to use that type of person or as a neutral. This can resolve many complaints about the choices parties are expected to make in selecting a person or a panel. So it's very important to give some forethought, a lot of advanced thought into what kind of people or person you're going to have in this. I may have to switch out here because I don't think my system is quite functioning, the Mentimeter. Let me see if I can try this. You'll have to do it this way. So Sophia, I'm going to ask the audience here to go ahead and answer this question 1. And if they could do it, the Mentimeter doesn't seem to want to pull that up. So let's go ahead and try it this way. If they could put it in the Telegram or onto YouTube to answer their question.
Okay, the only thing that right now I don't see.
I'll go ahead and stop sharing and reshare it a little differently. How about now?
So just a moment, because
little
right
delay.
Now, So actually on Mentimeter, we do have the questions only, but there is no voting option.
Yeah, the voting option doesn't seem to want to come up.
Okay, so then what we can do, we can just try to then answer the questions on Telegram or on YouTube. So, or maybe it will be fixed after a second, okay?
Yeah, let's try that, give it a try since it's not pulling it up. Okay, so an arbitration clause may include all except. So take a look at these: A, B, C, or D. Mandated mediation participation, a requirement to litigate, mandatory arbitration of disputes, mandatory participation in a settlement conference. Arbitration clause may include all except A, B, C, or D.
Okay, so at the moment, so we have no one who is talking on YouTube, but we have a couple of people who wrote out to me, and they say that it's B. So some of them answering B, some are answering D.
Give it a little bit of time here and see if we can get a couple more.
Okay.
An arbitration clause may include all except. Let's see what people think, and then we're going to get into them. So some people thought it was B.
Yes, absolutely correct. Someone thought it was B and someone thought that it was D. So mostly everyone was for
try
D.
them in let's try them in order and see how we come up. So let's say, no, it's not A. Okay. Mandated mediation participation, no. And then a requirement to litigate.
Yes.
Correct. Okay. And then we had some with C, mandatory arbitration of disputes, and D, mandatory participation in a settlement conference. So the one that is correct is a requirement to litigate. Okay. So all of those are in the clause there. So how many do we have in B? Is that the majority, you think?
It is the majority, yes. So,
good.
And there is a question in general. There was one question which came up. So if you can just explain very briefly, like in 2 words, what's the difference between arbitration and litigation? Because these are the major 2 ways as someone is writing to resolve the disputes in general, because someone doesn't have a very good command of English. So, and litigation is usually a little bit horrifying term for everyone. Yeah,
we're gonna if I could answer that in just a moment, because we're gonna get into that would be perfect. And because I'll probably have to repeat myself if I don't just stay with the PowerPoint for now. Okay, so I'm gonna go ahead and jump out of here, and we're gonna go back to, I'm sorry that that's not working Mentimeter today. I don't know why, but that's okay.
We'll figure it out. That's okay.
We'll figure it out. Yeah. Let me see here. Okay. Makes my negotiation on this a little bit more challenging, but that's okay.
Maybe you can try reboot Mentimeter, and sometimes it gives exactly the number, and people can go and fill in the number. Maybe this will work, not through the link, but maybe through the numbers. There
we go. I'm back here now. I can try it in a minute.
Okay.
Let me see how we do here. Okay, so that's good. So majority of the people got that correct from what I understand. Fantastic. So here's some of the stuff we were just talking about, and kind of a refresher on the types of ADR that are possible, and maybe some hybrid methods that you might use. So some hybrid methods of dispute resolution are mediation, arbitration, med-arb, and then conciliation and arbitration together, concilio arbitration. Okay, just to have some terms that I'm going to put out there. And we're going to get into what these are. I just want you to be familiar with what I'm talking about. Okay. So the gradation of dispute resolution methods and gradation. When we have non-binding compared to binding, you'll see in the top screen. Non-binding are those methods that the parties are not obligated to. The one in the pink or the shaded color says binding. Those are the ones that are resolved in a manner in which the parties are bound. Decision by disputing parties in the lower end on the left, and the decision by a third party or the neutral or a judge on the other side, or arbitral tribunal. And then we have alternative dispute resolution there, finally in the yellow. So it's a great way to take a look at all of the various methods that I mentioned earlier. From avoidance, obviously, you could duck out of an issue. You could avoid the issue simply by not pursuing it, as one of the parties might do, all the way up to the other end of the continuum, which is litigation. And litigation is obviously being in court and having in front of a judge and having a final decision made, an obligation or a binding finding decision, and everything in between. So those are the things we're going to talk a little bit about first. An ounce of mediation is worth a pound of arbitration and a ton of litigation. I think that's a very interesting quote. An ounce of mediation is worth a pound of arbitration and a ton of litigation. So in my view, that's absolutely true from what I have seen in the legal world, where people have gone to court, spent a lot of time, a lot of money, a lot of heartache, and they've lost really good relationships, both business and personal relationships over going to litigation. And I know that's kind of what everybody wants to do. But let's take a look at some of the issues we might resolve outside of the courtroom. So ADR is any method of resolving disputes other than by litigation. So some of the methods include civil disputes occur when a person's rights have been infringed or an individual has been injured as a result of another person's action or inaction. Those are some of the disputes that we might find in civil litigation. ADR involves settling a civil legal dispute by method other than a decision before a court. And is ADR appropriate in criminal disputes? So that's some of the time. Sometimes people will ask that, is ADR, alternative dispute resolution, really appropriate for a criminal dispute? And some of the things that have been bandied around or discussed here in California, I know some of the judges that I've spoken with have discussed this topic. So something to think about here while we're going through our discussion. Avoidance. So what is avoidance? Let's just start with that one. This is an intentional plan to avoid development of resentment by sorting out critical issues independently without challenging or settling the other party. An intentional plan to avoid the development of a resentment. So you want to keep your relationship and avoid the problem. Negotiation involves two or more parties when competing or conflicting interests or needs working towards an agreement on how they will cooperate. And negotiation is a process of finding a point of balance between your objective and that of the other party. I'm going to stop here for a second, and I'm going to go to our questions again.
Well, actually, Daniel, we could see, maybe you can still go on with Mentimeter, because actually we could, through the link, we could see the presentation perfectly. It worked. So let's try voting over there.
Okay, we can try that.
Yeah.
No, it's not pulling it. It's not pulling it up.
Oh, so it doesn't get the questions, yes, as I understand.
No, I don't know why that doesn't do it.
Okay.
But it's not functioning today. I'm sorry.
It's okay. It
Technology.
happens, but we still have the people who are on YouTube. So, and I can deduct, I can get the answers from there.
Okay. I think it's valuable to have the questions regardless, even though it might not be as seamless today. We'll try to make it better for next time. Okay, so for ADR clauses to be enforceable, they must be, and we got A, B, C, or D, clearly written, inclusive of all necessary information, consistent, was consented to by all parties, or D, all of the above. So for ADR clauses to be enforceable, they must be clearly written, inclusive of all necessary information, consented to by all parties, or D, all of the above. I'll give you a couple seconds here to work on that.
Okay, so I am getting the answers on chat via YouTube, on YouTube. So most, like 85% are saying that it's D, and several people are convinced that it's C. So majority are for D, like over 80%. Some are for C.
Okay, so let's see. Does it need to be clearly written? Well, that's the incorrect answer, but that doesn't mean it's not correct. So let's take a look. B, not the correct answer. And then a lot of them are saying C. That's not correct. So obviously it is D. So it is all of the above. That is correct. Yeah, it would make sense. It does need to be clearly written. That is a lot of what we're talking about in this particular series that we're involved in here, is how to write more clearly, inclusive of all necessary information. Yes, we don't want to leave anything out. We want to have all of the particulars in our clause consented to by all the parties. We couldn't really call it a contract if we didn't have everybody agreeing to everything that was in our clause. So obviously we want to have that involved. So D, yes, all of the above. For all of you that got that correct, very good. Another one. So negotiation we spoke of. Avoidance was one, negotiation was another. And here's another quote. In the middle of every difficulty lies opportunity. Albert Einstein. And these are excellent quotes because I think they get to the crux, to the particular of what mediation or arbitration, alternative dispute resolution is all about, is trying to find ways of resolving the dispute without actually taking a very difficult decision, which is the very end of our continuum, which is litigation. So we don't want that if we don't have to. 7 elements of negotiation. Interest, what do the parties want? So options, what are likely areas of agreement? And as you're going through negotiations, you should have this list in front of you. As I spoke of earlier, when you have an agreement that you're contriving, that you're drafting, you should have other elements in front of you to see what you're going to put in. Alternatives, what if we don't agree? Legitimacy, how persuasive is each party? Communication, are both parties willing to discuss and listen? And Sophia, do you have evidence that you that is presented to both parties? In our legal system, we have to present the evidence to the other party that you're going to use in court. Discovery?
Yes, absolutely. Yes.
Okay. I know that some systems don't, and that's why I was curious, because the communication can get very dicey, get very difficult.
Yes.
Yeah. In ADR, that's one of the complaints. I think that most of the time people will hear the parties will say, well, if it's not binding, or if I want to take further action, I've given all of my information prior to going to litigation to the other party. And the discovery is done in a mediation or arbitration. Is that wise to do? Okay, so these are some of the things to discuss with your client. What kind of communication are we going to have that are we going to disclose to both parties? The relationship, are both parties ready to establish operational relationship? And commitment, what's the structure of commitment from both parties? So there's some really good issues in negotiation. The negotiation process prepare objectives and strategy, discussion, exchange information, again, discovery, propose a solution, bargain and review areas of concession, and conclude or draft and endorse an agreement. All big issues. So you might have a list of examples of following, like informal negotiation or formal negotiation. Informal meaning that you're doing so outside of the courtroom or outside of the mediator or arbitrator's office. There might be some informal between the attorneys. Formal negotiation might be in a more formal setting, like in the offices of a third party or in one of the offices of the attorneys that are present or representing their clients. Unassisted negotiation involves the disputing parties systematically reviewing identified challenges and arrive at a feasible agreement without a third party. Or partnering is a form of unassisted negotiation. So I'm going to get into this in a minute, but I've got some examples I can show you. of mediation and negotiation. Negotiation involves two parties discussing and compromising to obtain an agreed solution. And negotiation is usually carried out without legal representatives, but each party can take on their own legal representation to assist, and negotiation is not binding. And then we have facilitated negotiation, another form. And this is a form of negotiation where a neutral person will be invited to guide the disputing parties towards reaching an agreement. A dispute board is a formal facilitated negotiation. Or an early neutral expert evaluation. And sometimes the parties will turn to a neutral that is an expert in the field, which is a form of dispute resolution. Features use of industrial or industry expert or top practicing professional to function as an independent reviewer and conduct unbiased evaluation of the burning points of matter at stake, rendering solution-oriented counsel capable of ending that dispute if accepted by parties concerns or concerned. And I'm going to talk about mediation here for a minute, then I'm going to change to a little different issue here. I might go to, I think I will go to our questions again and try that.
Okay,
there we go.
Mm-hmm.
So question 3. An arbitration clause that includes at least 2 types of ADR proceeding is called a multi-layer clause, a problem-solving clause, a single-layered clause, or a prevention clause. An ADR clause that includes at least 2 types of ADR proceeding. So we're giving you lots of background here, lots of background to write your clauses with. Give you a few seconds here to figure that one out.
Yeah, so we need some time because we have this little layoff of time, a little bit. So and
little delay.
A little, yes, delay. So and I will keep quiet. So what if I make a mistake? So over here, because I'm not a specialist in ADR clauses. So we are already getting some answers.
Very good.
So, and everyone is saying A. So for now, everyone is saying A.
We will see.
A, not even any other option. Just A.
Just A. So correct, a multi-layered clause. Very good.
Thank you,
A
everyone.
multi-layered clause. So when you have 2 or at least 2 types of ADR proceeding, at least 2 types. So mediation is an ADR mechanism in which disputing parties allow an independent third party. So before this, we were just discussing negotiation or avoidance to help them reach a point of settlement. Mediation clause is the contract between the disputing parties. Should point out terms of mediation, including choice of mediator. Okay, the mediation clause in the contract between the disputing parties should point out the terms of mediation, including the mediator. The disputing parties agree to mediate. Disputing parties select acceptable mediator, and decisions are made by disputing parties. Okay, so in California, let me see if I have this. Here's a photograph of some of my students. They're all at a church, which sometimes when we have lower level mediation, they will go to the parties will go to the church, and it will be for various issues. And so what I'm going to ask you, Sophia, maybe you can answer for the group there. What are some of the issues that are the most mediated in Russia?
Well, that's actually a very good question. And I think that we will just address these to our audience, and we will ask them to write what is in their opinion. If you can please write into chat on our YouTube channel or in Telegram. So what are the most mediated issues? I can maybe answer another question, so not that specific. Mediation is becoming more and more in demand in Russia. But in Russia, we had some interesting situation. We speak about, in general, alternative dispute resolution. We used to have enormous amount of arbitration institutions. There were over several hundred of them all over Russia. And then they were all abolished. And after some period, it was about like 5-6 years ago, probably 7, something like this, we have now left only 4 institutions in Russia, which are arbitration institutions where the parties can refer to. The idea behind that, and it was a shock for everyone. So the idea was behind, as I understand, maybe some of our viewers can correct me. The idea was that because the parties, although the arbitration was binding upon the parties, they still were not happy very often with the decision of or award of arbitration institutions, and they still referred to litigation. That was the official explanation. So there was no point in kind of spending and wasting the time and money, and it was easier to get to litigation. Right now, mediation is really going up, and we have a lot of specialists who are focusing on mediation and trying to attract parties to refer to this form of alternative dispute resolution. And Daniel, we have actually the answers to your question about which are the most mediated issues in Russia. Family problems, family disputes, commercial disagreements, so mostly family disputes and sometimes business disputes. So thank you very much, our participants. So these
it's very similar here in California, and many of the disputes that we have, I showed you the 2 cars that were crashed together. So those sometimes will be mediated, and a lot of landlord-tenant disagreements.
Yes.
So those are probably the highest, really, landlord-tenant, and there's kind of a tie between that and domestic issues.
Yes, we don't have usually such disputes because of specifics of residential lease in Russia, just because a lot of leases, when people lease the apartments from landlords, they are not in any registers. So, and that's why it's usually very personal. So they usually do not refer to any mediation or any outside source.
Very good.
I also have, and one more addition from our viewers, thank you very much, that employment law, employment disputes, maybe also the third, which is very often mediated, I would say.
Yeah, that is true. And we have the industrial board for resolving conflict between employers and employees, Department of Industrial Relations. We call it the labor board here in America. It's a federal agency that oversees at administrative law judge level disputes between employees and employers, and it's no cost to the employee. There's really no cost to the employer as well, but obviously if there's a finding against, many times the finding is against the employer, not always, but many times. So then you can appeal that and actually go to the Superior Court.
And can we ask one more question related to this? So in general, as I understand, the idea or behind any form of alternative dispute resolution is that it's not governmental. Yes, it's not the system of state courts. So
the mediation.
Yes, and usually these are private institutions. Am I correct in this or not? Or any state authorities, governmental authorities can offer the mediation to the people? So is it private based or state based? Or...
This is exactly the reason I'm showing the video or the photographs, the images that I'm showing and discussing this, so that we can kind of separate the definitions of what these are. So with mediation, it's non-binding, and the parties have to agree to mediate. And usually, what will happen in this case, this is a church that is in Los Angeles.
Yes.
Los Angeles has the largest court system in the United States, very large, over 100 courtrooms there, and they deal with a lot of smaller cases that should probably be resolved outside of litigation. So that's what the court system you're talking about. Is it government? Is it not government?
Yes.
So generally, and this is the whole plan, is the county of Los Angeles is they oversee that particular court system, and they will provide grant funding for mediation. So, and it's millions and millions of dollars to try to get people to resolve their conflict outside of the courtroom. So it is funded. A lot of it is funded by government. So even it's pseudo government because it's funded by the government, but the mediation is not mandatory. But what'll happen is in this particular picture in front of you is a church, and that church has a mediation center. So that leases space from the church. And actually, one of the professors here, one of the founding professors of our resolution program, dispute resolution program, started this particular mediation center at this church, not too far from Pepperdine University. And it's for people to go and to resolve conflicts that are of a minimal amount of money, or minimal in terms of the dispute value in dollars. Now, it could be a big issue to the individual, obviously a lot of emotion. That's why they're taking it to some formal, higher level.
Party. Yeah.
Yeah. So what happens in the court is that the judge will have the parties come into the courtroom on the day of their small claims court case. It's up to, I think, $15,000 now that they can dispute a case in a small claims court. The cost is nominal. You don't have to be represented by an attorney. And the judge will bring all of the people in. There will probably be hundreds of people there that day. And he will say to all of the people at once, all of the audience, is that you are here to have your case heard in front of the court. But instead of me hearing every single case, because I only have maybe 5 minutes, maybe 3 minutes to hear, because there's too many cases. Yes. Yeah. I would strongly recommend each of you go into the hallway. We have mediators outside in the hallway, and you discuss your issues with them. You give discovery to the other party to let them know what you're going to show me in court. If you don't show it, I will not look at it. So you have to show it to the other party. And then the mediator will help you resolve the case if it's possible. And the judge will normally say something like, if you come back into the court and you still have not resolved your case, I will hear it, but I will only have a few minutes, and you will probably both be very unhappy with my decision.
That's very straightforward. Yes, like go to mediation.
They don't have very much time. There's too many cases and too many people, not enough time. So generally, the cases will be heard by a mediator. There's a form that they complete. The parties will complete a form, and that form will state that they have discussed the mediation. They either did or did not come to a resolution. If they did come to a resolution, the resolution will be documented. Then it goes back into the courtroom. The judge will review the document, review the resolution, and say, okay, I agree, or no, I disagree, and here's what I will do instead. Okay, so he will actually, or she will look at the settlement, and sometimes it's a matter of tools that were taken by one party and they were not returned to the other, and it's okay, I'll give them back. Or so
it's not like
emotional.
Mostly emotional, not even the financial.
So it's a great way of resolving conflict outside the courtroom, and it's well worth the money that the government will spend in grant funding alternative dispute resolutions instead of tying up the court's time. So it is documented. Once it's documented, the judge will sign the findings, sign the settlement. Then in what we're talking about today is how do we enforce that?
Yes.
Well, if the parties leave and they've signed the agreement, if one party or the other does not comply with the agreement, then it can come back to the court. You know, the offended party can come back to the court and say, we came to you, you resolved it, or we resolved it, you signed it, and the judge can then have another order for additional compensation or additional damages that were owed the offended party. And it can go on the person's credit report so that their credit will be harmed. They can go to a third party and have a collection agency collect the funds if there's funds they're due. So there are ways to put teeth into enforcement.
Enforcement, yes. But as I understand, but still, after they have signed the mediation settlement, they cannot go directly to some enforcement officer. So they need still to go through the court. Yes, if they're getting back, if the party was not fulfilling was not in compliance with the settlement. So it's still through the court.
Once you have that judgment, you know, by the judge, once you have that judgment in the settlement agreement, generally what you can do, many people do not, but I've had situations being in business and doing other things where I've had to take this case to where somebody owes money for back rent or some other issue, and you can go to a collection agency. They take a percentage of the collected funds when they do collect them. So
and can I ask you, how much do they usually take, if you know, maybe?
And see, that's interesting because it depends. And the reason I say that is because it could be an issue to where the person in their past has been a very difficult person to collect from. So you would negotiate that with your collection agency. And if it was a very difficult one to collect, you might get half. If it was an easy one to collect where the person had a very stable income from maybe a government job, then they could attach their wages, is what we call it. They would put an order in, the judge would put an order in, if you went back to court and you knew where the person worked and said 20% of that person's income is going to be paid towards the settlement of this case until it's paid in full, or something like that.
So it's also negotiation here. So
it's negotiation
everywhere. Yeah. Okay.
But it depends on the issues. But I hope that helps solve some of the issues there with mediation, the difference between mediation. We got a few more slides here about mediation, but it's an excellent way to resolve conflict without a huge expense. The litigation obviously is very expensive, and time consuming, and maybe it's just a matter of resolving the conflict because people are emotional and they just need to be heard.
But what is amazing that the settlement can be enforced. Yes. That's the main point. So
it's not 100%. Obviously, you can never.
Yes, you can never be sure, but still,
there's mechanisms.
Yes, there is a mechanism. Thank you very much. Okay.
Yeah, this is a very good way to resolve conflict is through mediation.
And we never have mediation in the church. That's for sure. So that's very American thing.
Well, the church is there's a lot of churches in America. America has so many different religions, and it's a freedom that we cherish. So there's every type of religion possible. And many times the churches will lease out or rent out space in the church for issues that are maybe support the mission of the church, like resolving conflict. So those are very good.
Maybe I'm just not aware of any situations that we have in our church, or we also have a lot of, in Russia, many denominations and religious. So maybe they do something like that. So I've never just heard of that. So maybe it also happens. It's just really interesting to research this. Thank you very much. And Okay, so, and we have some comments that in Russia, we also have financial commissioner as an example, as I understand that some person who also helps to resolve some of the financial.
Interesting.
Mm-hmm.
I'll have to look that up.
Yeah,
so
thank you very much. I'm
You're
giving
welcome.
the floor back to you. Mm-hmm.
All right, thank you. So 7 steps to mediation: choose a mediator, identify objectives of both sides. And usually what will happen is the mediator will either speak in each party individually and then come back together as a table, decide mediation schedule. And sometimes we have co-mediation, which is interesting. I might want to mention that, where we'll have 2 mediators, one for each side, or working together to mediate. Engage the other party in declaration of position, discuss with the mediator shuttle diplomacy back and forth, trying to find a resolution. Once we have everything out there on the table, we've begun the discussion, the mediator can then shuttle between the two to try to find a resolution. And then endorsing the deal. And that's when in the court, small claims court system, as an example I gave earlier, to where we would write it in, put it in writing, and then have it approved by a judge. So mediation involves an impartial third party who listens and directs discussion, but does not suggest outcomes. It is voluntary. All parties have their say. The atmosphere is informal. Mediation is non-binding. Okay. There can also be more formality to it if you want to hold it in your attorney's office, or like in the third party of a church, for example. Disputes unsuitable for mediation, and that sometimes is asked, are circumstances where both parties are not willing to attend mediation. And this sometimes will come up because there will be a mediation clause written into a contract, but the one party or the other, or even both, do not take it seriously. And sometimes the clause will state something to the effect that the mediation must be completed prior to going to litigation. So both parties are obligated to go to mediation, but there's no binding situation behind it. So they might send a clerk or somebody of lesser importance just to sit in the mediation that's not really serious, and just to show that they've gone to mediation. So that can be a problem. Disputes where there is no continuing relationship between the parties. There's no continuing relationship between the parties. It may not be suitable. Disputes where there is evidence of gross imbalance of power, and that can happen where we have parties. An example of that might be in some domestic disputes, to where one spouse holds a very substantial job and has a very high income and one does not. That may not be the best situation to give equity to both sides fairly. In California, we have a 50-50 split when there's a divorce. So if there's one side that has too much power, that might not work well. Where there are overwhelming emotions involved might not be good. And where there is a history of broken promises. The next one's conciliation. Is similar. I think I'll stop here for a minute. Let's try another question. And motions for enforcement of Adr clause include all of the following except a statement of facts, details of the Adr clause, a legal argument for enforcement, and an argument against the validity of the Adr clause. So motions.
Yeah, and can you please explain, Daniel, what does it mean, emotion? Because just
so
briefly, yes, what's the difference between a claim and emotion, for example?
Emotion, well, emotion would be the enforcement would be to where, an example I provided before, where an aggrieved party that was not not receiving satisfaction from a prior agreement would motion the court saying that a clause has been violated in our ADR. And so what can we do?
Yes, in Russian we call it ходатайство. Can you say the synonym as petition? Can you say that you can
petition
the court Okay, then in Russian it would mean ходатайство. Okay, thank you very much. It's just trying to explain it to those who are not having a good command of English. So, okay, so.
So a statement of the facts, details of the ADR clause, a legal argument for enforcement, an argument against the validity of the ADR clause. Motions for ADR or for enforcement of the ADR clause include all the following except, so you see that little except there at the end. Which one does not belong?
So the answers that we are getting in our YouTube chat, everyone is for everyone. Actually, there are no exceptions, is for D.
D.
Yes.
That is correct.
Good.
An argument against the validity of the clause. So obviously, it would include all of them because you're arguing that there are a statement of facts, there are details of the clause itself, and a legal argument for the enforcement for the judge to go forward. So perfect. Great.
Thank you very much, our participants. Good
We're
job.
getting the clauses down. So conciliation is similar to mediation, except for the role or active role of the third party, the conciliator, in putting forward suggestions of compromise. It's structured to bring disputing parties to acceptable agreement through concessions. Okay, so rather than being as neutral, you have a conciliator situation. So do you have that kind of a situation there in Russia?
Yes, just a second. Sorry, I was just
No
turning on my. So we do have it, but as I understand, we usually have it in labor disputes. So
Labor disputes.
This is where such mechanism is applied. So for the rest, usually we're referring to mediation. So if there is a chance. So conciliation is very, very specific usually for labor disputes, but maybe someone can comment on this and we'll add the other areas of law if there are some specialists in the other areas of law.
Very good. Thank you.
But
Another
we don't
one
have, yes, the only just one clarification is that in Russia, we do not have any employment tribunals like state system of state courts. We have employment commission, so or something like this. So and very often the employers and employees are trying to refer to conciliation first, so without resorting to this commission. Good. Okay. That's all.
And then we have an ombudsman. Corporate ombudsman is employee appointed by a company to resolve disputes therein. So employment contracts, like you were discussing, were some of the issues there. A person appointed by industry association to resolve disputes between the parties. And sometimes the labor union will have something, an ombudsman there. A government ombudsman is a person appointed by government to resolve dispute between people and government. Commission to set up and resolve dispute between entities and government, for example, public complaints commission comprising commissioners and headed by the chief commissioner. The commissioners have great latitude of power to investigate, inspect, and adjudicate. And an ombudsman appointed by government is identified as a defender of citizens, ensuring objectivity and fairness to citizens at large. So we do use this quite a bit to resolve conflict. Peer review panel is another one. This is a dispute resolution method in which peers, such as managers, shall be placed in a panel to evaluate and resolve matters pertaining to their colleagues, for example. And judicial dispute resolution, JDR, is a confidential pretrial settlement conference led by a judge. And that's very common here in the United States, where we have a pretrial conference, settlement conference. Many times we're going to be talking about JAMS, or Judicial Arbitration Mediation Service, or AAA. Some of those judges will go on after they retire, work there, but they do a lot of pretrial stuff themselves. In America, the judges that I work with generally told me that a very, very low percentage of their cases actually go to trial. So that the number of cases that they'll receive, there's probably 2% that go to trial. The rest are solved out of trial. It's very interesting. So they do a lot of pretrial conferences. The objective of JDR is to resolve the dispute. So a trial will either be unnecessary or at most limited to those issues on which the parties do not agree. The parties meet with a judge or justice to confidentially discuss the background of the case and what the parties feel is important in the case. The participants then discuss possible solutions. If no agreement is reached, the judge or justice may give a non-binding opinion of what decision they would make if the case and these facts were presented at trial. Okay, the judge or justice's non-binding opinion may help the parties or their lawyers reach a resolution without having to go to trial. A settlement is only reached if everyone agrees. So you can see the benefit of having JDR, or pre-trial conference, to where the judge is asking questions, given information, and then gives insights to the lawyers for the parties so that they might better understand how the judge might rule or how the judge thinks a jury might anticipate what is going to happen. And
can I ask a question over here?
Sure.
We had a question which arose. Is this such mechanism or such type of resolution, is it offered to every case, or is it like there's some threshold or the volume? I don't know if it's like commercial cases, like what does it depend on, or it's just a mechanism which is offered for everyone?
It's a mechanism that's pretty much offered for everyone.
Mm-hmm.
There's very few that I think that don't take advantage of a pretrial conference, or that the judge is not asked for a pretrial conference because they want to resolve it without having to actually take it to trial. Most judges want to clear their calendar.
Mm-hmm.
And so, yeah. And if they can nudge the parties, so to speak, if they can say, let's kind of get this moving along. I think we have enough information out there for the parties to maybe take another look to
Mm-hmm.
find a way to resolve this without having to actually go through the trial process. And like I said, it may not be the judge that is responsible for making a decision. It's just that the involvement of the judge or the justice in asking the right questions or giving insights to both parties that might lead them to think, well, we might need to take another look. Maybe we need to negotiate a little more and find a solution.
Mm-hmm.
And that's generally what will happen.
And can I ask you a question, please? We
Mm-hmm.
had this question that arose actually in a lot of classes of legal English that we are having, that a lot of people who are non-native speakers, they use the word to settle and to resolve a dispute as synonyms. So, and we're trying to say that no, they are different. So to settle a dispute means one thing, to resolve a dispute means the other thing. What is your opinion? Can they be used synonyms, or they really are apart from each other, to settle dispute and to resolve a dispute?
I think they're both related, but one can be more one or the other can be more defined mm-hmm. in specific situations. And especially when you're dealing with people in resolving conflict in areas where there's a lot of emotion. So to resolve the conflict might mean to find solutions to where both parties can feel that they have benefited. Mm-hmm. And generally in a settlement, that might connotate one party feeling as though they've been found more responsible than the other.
Yeah, and they have to give up something because they...
Right. So there's that feeling of giving up rather than both parties receiving. If you're settling the case, it means somebody's probably going to be paying monetarily or financially, Not always the case, but there's that feeling that that is the case when you're using that word, a settlement, compared to resolving the case might mean that maybe neither party received anything.
Yeah, or maybe they just drink a cup of coffee and that is enough. Yes.
Maybe they misunderstood the dispute and both parties are satisfied that let's just, avoidance, that first part, we'll just both avoid the problem and we'll just continue to do business together. Maybe the relationship's more important.
Okay, so, thank you very much, because very often even such questions arise.
Settlement would indicate that somebody had to do something, had to act either monetarily or to provide some form of compensation. So the next one will be arbitration, and arbitration. Let me see if I can. I'm going to go ahead and stop sharing here again because it's not working quite the way I wanted. And I'm going to go to. Can you see another PowerPoint here now?
Yes, absolutely.
Okay, so this is JAMS, and that's the Judicial Arbitration Mediation Service there in Los Angeles. It's, if you see the Los Angeles skyline of all the buildings there and in the movies and different stuff, that's where it's at. And there's some of my students there attending JAMS. We go there every so often and take a look and see what they do, because I like to go to like the church we spoke of, which is very low level, and then we'll generally go to an office of a mid-level arbitrator or mediator, not really an arbitrator, but a mediator. Most of the time they do some arbitration. And then this is kind of the high level of arbitration. So JAMS is well known, and very beautiful offices there. And they provide 1 Wilshire Avenue or Wilshire Boulevard. Yeah. And one of our students that graduated from the LLM from Pepperdine works here, and he's a professor now. And his office, he's Brazilian, but he's done a lot of international commercial arbitration, and that's what he still does out of this office here. And this is back in our building there at JAMS Foundation. They do a lot of giving for various causes as well. And you can see, the reason I'm showing these is because I'm trying to give a feel for what it's like in arbitration in America, at a high level. Yeah. And they do several $1 billion a year worth of arbitration cases. And there's 300 judges that work here, that retired, either judges or they're specialists in various fields. We'll talk about that in a minute, what the arbitrators do.
Yes, that's actually the question was from one of our participants, like who becomes the specialists in this. But this is so interesting. Thank you so much, because we get a chance to actually see something that I doubt that a lot of foreigners actually get to see. Amazing.
It's a fantastic location for arbitration in Los Angeles, because we have so many cases that are done that come through internationally in that area from all over the world. And the kinds of disputes that are settled there are very large. Normally, the judges that work there generally are paid $5,000 to maybe $20,000 per day to resolve the case, and they're paid a lot of money, but compared to the cost of litigation, it's very low. So they can go in, and within a couple of days, the arbiter or the tribunal, if that's what you choose between the parties, or if it's in the contract, it's part of the clause, generally they can sit at the table here. You can see the woman in the white that's nearest us. She would be sitting in one of the chairs of 3 arbitral tribunal. Or you would have one if it were just one arbiter, and then you have both sides, one side for each of the parties, and then you have the big screen in case you want to have somebody from outside the area that is also contributing, or if there's evidence that's being presented. Another interesting part of this, I don't have the slide here for that, but there's an actual courtroom that they have built. It's a replica of the court, so that the parties can actually have 12 jurors come in that they will select, the peers, and the parties will present their case just as they would in court.
But it is arbitration. Yes, so it's arbitration, but with jurors.
Right. And they will actually have the jurors come in, listen to all of the evidence that would be presented through discovery, and then give their finding. And the arbiter would look it over and then present it to the parties for them to do, very similar to what we just spoke about with the judicial judicial arbitration.
Yes.
Right.
Yeah.
So what would happen is the parties would review what the jurors would find, and from that, even though it's not binding, would be able to determine where they might go in case it did go to actual court, to go to trial. So it's an excellent way of resolving major cases without having to actually go to trial. So some of the benefits of that is it doesn't go into the legal system. So, you know, when you in America or in California, when you file the case, it becomes public record. Yes. So we have a lot of issues to where the parties don't want it to become public.
And they want to disclose any information, and just the fact that any of the dispute has taken place.
Yeah. So it's an amazing place to where we can have a lot of athletes that are in dispute with their team, or we can have Hollywood actors in dispute in a divorce, or cases where they don't want something to come out public from a corporate issue.
And Los Angeles is exactly the place where everything like this happens. So
it's a really fun place to look at. There's a couple people in this photo. This one up here is a judge in Brazil. There's several of them in there that are there to get a review of what JAMS does.
So, and I just wanted to remind everyone so that Daniel is a professor at Pepperdine University Strauss Institute for Dispute Resolution, which is #1 in the United States in ratings on international contracts, corporate law, and alternative dispute resolution. So, and I would like to specify that, as I understand, the topic of our 2-day webinar is exactly your specialty, big time, if I may say so.
Yeah, it's a very growing area in America. In there, we have the same issues that you spoke of earlier, with Russia expanding into ADR, maybe in arbitration, and then contracting a little. Some of the cases, because of the type of system we have in America, where the states have their own standing, and then we have the federal system, which I showed in the intro, the very first session we had. So in California, it's more progressive normally in some ways, and we have the legalization of marijuana, for example, and so it's still illegal federally. So it's a case where you wouldn't want to bring it to trial, because then you would alert the federal system that you have an illegal activity at the federal level.
This needs to be taken into consideration.
So a large growth area for JAMS is in resolving conflict in the medicinal marijuana or marijuana use area, because if they bring it to trial, there's a possibility, not that it would, but there's a possibility that assets could be seized, bank accounts could be seized by the federal government. So the parties are really reluctant to resolve their conflict that way. And obviously the resolution of conflict means doing it in a way that is peaceful, and we want that to happen. So this is a good alternative for the parties to find it.
It's an amazing alternative. Yes, so you just do it your own way, how you decide. And the fact that you can actually even invite the 12 jurors, I'm not a specialist in here. I've never heard of it, honestly. So that is a great discovery of the day for me today. So thank you so much. Fantastic.
And here's some of the people, the ambassador, just a lot of retired judges that, and getting back to your question you had earlier was, stop sharing that and go back to our PowerPoint or our MIDI, is when we're talking about arbitration, just briefly here, and then I'll talk about the people that do it. It's a formal submission of dispute, formal submission of dispute to one or more arbitrators for a decision to be reached. This is a quasi-judicial method. Arbitration clause in the contract shows the terms of arbitration between the parties. So that's a lot of what's been done in America or in California. In a lot of the agreements, it becomes a boilerplate, a clause to deter for companies to turn to arbitration as a mandatory part of that contract. Decisions are voluntary, binding, depending upon the terms of the arbitration as enshrined in the arbitration clause. Okay, so it's one of those it depends types questions you might have that's coming up is is it binding or is it not? It depends. Okay, so it all depends on how the clause is written. Court imposed arbitration is binding. So if the court does impose arbitration, then it is binding. So some advanced choices you have to make that are very important. Again, getting back to what I started with is advanced thought needs to be given to the types of people who would best resolve a dispute likely to arise under a particular contract, and an agreement in which to use that type of person as a neutral. This can resolve many complaints about the choices parties are expected to make in selecting arbiter or panel. So sample clauses specifying arbiter qualifications with varying degrees of specificity follow. So that was your question. We're going to look at that now. So the sole arbiter selected shall be, this would be a clause you might put in your contract. So the sole arbiter selected shall be a retired judge from a particular court. And you can see how a judge in a pretrial court settlement, we talked about before, the pretrial settlement where the judge is involved, those are the kinds of things where the judge might have an area of expertise, or cases that are particular to his specialty or her specialty are provided to them, are assigned to them. So they become well known for cases like in pharmaceutical cases, chemicals, or in engineering. So a lawyer with 10 years of active practice in a specific area, such as construction, an accountant, a licensed engineer trained in the specialty of blank engineering, electrical engineering, aerospace, or something to that effect. So these are excellent clauses to put in to think about in advance. If we're going to resolve something, who do we want to select? And then how do we select them? So sometimes people will ask, so who selects? Which party?
Yes, that was exactly, I just like trying
I see you go
the button to, you hear me already. Yes,
I do.
Like,
yeah.
who decides?
So that's part of what you would put in your contract as well. Okay, so you would have in there the kind of people that you would want, and then normally you would have in there that you'd have and this is all negotiated in the contract initially when you're signing the contract with the clause, is if a dispute were to arise and we were to go to arbitration, how would the arbiter or arbiters, the panel, be selected? And that would be done with maybe each party would submit 3 names from a list of, say, 10. So jams, for example, if you had in your clause that all of it would be resolved through jams or through AAA or one of the arbitral dispute organizations. So you'd say, oh, we're gonna settle it through jams. We're going to have a list of 10 names of judges or arbiters with expertise in the area of, and like it shows here, and they would provide that to us with who's available. And then you would choose, each side would choose 3 if you're going with a panel, or maybe they would choose 3 and see if there's an overlap, because maybe both sides would choose one that was the same.
Yeah,
and then obviously
that's the best. Yeah, that's the best solution. Yes, then.
Yeah, and if it came down to a tie, or if it came down to where the parties could not agree, that maybe the arbiter would then be able to choose one from, assuming that they're a neutral, somebody would be able to come up with a name that would suit both sides.
And can I ask you one more question?
Sure.
Just also coming out from our participant, how often are there complaints on the decision or award of the panel? Do they often arise or not? Or there is some mechanism that like stops these complaints?
Well, I'll get to that and I'll answer that in the next slide or two.
Okay.
So that'll be great, because that's a perfect question. That's one that gets asked quite a bit. And the level of satisfaction that the parties have after the dispute.
Yes,
so,
thank you very much for rephrasing. Yes, because in litigation, you can appeal if you're not happy what's here. Thank you. Mm-hmm.
Okay. So, and remind me if I don't get to it. We're running out of time, but I'll get to as much as I can. The panel of arbitrators shall be composed as follows. The chair shall be an attorney with at least 20 years of active litigation experience, or shall be a retired judge of a particular court. And that court would be assumed that it would be handling those kinds of cases. One of the wing arbitrators shall be an expert in an area such as construction. The chair must previously have served as a chair and sole arbitrator in at least blank arbitrations where an award was entered following a hearing on the merits. So that's another example. Two more. The arbitrator shall be a civil engineer, a practicing attorney specializing in construction law. In the event of any claims any claim exceeds blank, exclusive of interest and costs, the dispute shall be heard and determined by 3 arbiters consisting of persons qualified in civil engineering and so forth. So those are all really good examples. Advantages of ADR: often takes less time than court, generally cheaper than litigation, less formal than courts, confidential, unlike in a court, which is usually open to the public, held at more suitable venues, not adversarial, and therefore both parties can come away from the process feeling as if they have won. Okay, and there's some professional parties that you can look at. They're international in scope. American Arbiters Association among them. And another list, there's a large list of international from around the world is there. So if you review the role of industrial arbitration panel in Russia, we spoke about that kind of at the beginning. And tax appeal to tribunals another way. So before I get to litigation, let me answer your question and go ahead and can you restate that question for me, Sophia?
Yes, which one?
We were going to talk about arbitration.
Oh yes, I already, so just a moment. So what is the level of satisfaction after the award of the arbitrator or arbitrator panel? And are there any complaints, and can they be somehow handled with?
Yeah,
yes.
So what I have heard and what I've seen is that it's one of those things, it depends. And a lot of it depends on many things, because sometimes in an arbitration or even a mediation, but mostly in jams, the arbitration has been to where there's at least 2 parties and sometimes as many as 20.
Oh, yes.
So, and you'll have a lot of parties. So that's why it depends, because it depends on who's getting the best deal and who's getting perceived, or who's not getting as good a deal as they'd hoped. And a lot of times it's in construction, like it shows here. So you'll have a large construction project where there's a dispute, time delays, and who's responsible
and a
for
lot of
those delays.
Subcontractors, which are
subcontractors. Yeah. So if something delays a integral part of the project, then it delays all of the other parts. So and that can be very, very costly, to where businesses have turned down other projects to do this project, and then they can't complete the project they're on. So they've missed out on a lot of work. Who's going to pay or compensate for that lost revenue? So there's a lot of issues that come out of that, that maybe all the parties won't be as satisfied equally. And then it depends on international arbitration, on which venue is selected, because you select the venue or the court depending upon or the law, depending upon the parties in the agreement. So you could choose Dutch law for shipping issues, for example, because there's a lot of history.
Yes.
And in it.
Yes.
Yeah. So if it's in Dutch law, and if you're going to have that venue to have it heard there, or even in the United States, you could have it actually done here in the United States. But if you're going to hear it in an arbitral court, what are the laws in that jurisdiction? In one of the students I showed you that was from Brazil that works there at Wilshire, he was instrumental in helping years ago write in ADR legislation, so that in their constitution, when they changed their constitution to add more security to enforcement of ADR. So in America, when you in California especially, if there's an agreement that is had for alternative dispute resolution, especially arbitration, it's very unlikely that the court will overturn it unless there's substantial evidence to support the need to overturn the arbitrators' arbitral finding. And
if we speak about enforcement of arbitration clauses, if one party, so it is binding, as I understand, the word is binding as per, depending upon the parties, of course. So, and if it is binding upon the parties, how they can enforce it if the other party is not in compliance with the word. So who should they refer to?
Yeah, in enforcement, what you want to look at is again the venue in which it's being heard. If in America we have strong laws to support the collection, so if there's a finding in favor of one of the parties, you can actually file against the assets of the other party. So that's one way of doing it, is to collect on their assets or on their revenues. So you have a judgment, and you can enforce that judgment through the court. So the court will actually go in and determine if there's a way to collect, or you can go to a collection agency in America that will help collect that debt, either through the sale of assets or even forced bankruptcy if they have to collect the debt.
Okay, thank you very much. Thank you, and it's all clear.
We're getting closer to our time, but let me take a look here. I don't want to run over, just take anybody's time. So an ADR clause that specifies a forum is not useful to demonstrate what? A meeting of the minds, capacity of all parties to consent, the mutual intention of all parties, an acknowledgement of the rights that replace the litigation. So an ADR clause.
Yeah. Can I ask you, please, just to clarify a little bit, a term which a lot of Russian lawyers are not aware of is an American term, meeting of the minds. As I understand, it is equal to the British intention to enter into legally binding relationship. Yes. So if I'm not correct, then what is the difference between A and C? Because to me, it's kind of very close in meaning, or they are different.
Okay, so can you clarify that again? Meeting of the minds?
Yes, meeting of the minds, the difference, what is the difference between meeting of the minds? Because in my opinion, meeting of the minds, it's the same, is similar that the parties have intention to enter into legally binding relationship. And then what's the difference then between A and C? Meeting of the minds and mutual intentions of the parties. The word mutual or not. So
very, very similar. So yeah, very, very similar. The mutual intention of the parties. It probably, if you're going to look at this, a meeting of the minds may be that that both parties agree. Okay, mutual intentions of the parties, they may not agree, but they have the same intent, or all of the parties.
Okay. Yes.
That makes sense.
Yes, it makes sense. Now
okay.
It's understandable.
Meeting of the minds probably means they agree. Okay, they're in agreement. Where the mutual intention of the parties, they can have the same intentions, but maybe they don't agree.
Okay, thank you very much.
So let's see what we have here.
Just a second.
Okay.
I will tell you then what kind of answers we have.
Oh, good. Okay.
So we do have some voting in here. So we have, actually majority says B, but also we have C as an answer. So, but majority is B.
So an ADR clause that specifies a forum is not useful to discriminate or to demonstrate a meeting of the minds. No. Capacity of the parties to consent. Okay. Yeah, the capacity of the parties to consent. And it is not the mutual intention of the parties, and nor is it acknowledgement of the rights that replace the litigation. Okay. Just a forum. It's not useful. Okay, so let's take a look for just a few more minutes here we have left. Are there questions you might have? Litigation is kind of our last topic, which I think most of your audience is probably pretty familiar with litigation and the cost that's involved. That's our last slide there anyway. We're real close to it. Abraham Lincoln discouraged litigation. He was an attorney himself, if you recall. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often the real loser in fees and expenses and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man. There will still be business enough.
Wonderful words.
Yeah, wonderful. So
right.
True.
And
we're all advocates for something, and in the legal field, being an advocate can be a two-edged sword, a two-sided sword. So we want to keep in mind the intention of the parties that I start off with every time, to keep their concerns in your mind at all times.
Thank you very much. Thank you, especially with the wording, and there were really a lot of very nice quotations or citations that you used in here, and we got the point. So
I have a lot of other things that I wished we had time to go over today. Maybe next time we'll get into some more, but some issues of some free writing that might help the students with their writing, or your participants. Some things that we can do here with what we call determiners. Maybe next time I'll start off with some of those.
Yes, we can actually work on this next time. So because we are now living from the topic of the language of contract drafting. So we had out of 4 our webinars, Daniel, you have spoken, 3 of them were dedicated to our language of contracts. So we talked about major contractual provisions, minor contractual provisions, and today enforcement mechanism of arbitration clauses. The first, you talked about legal writing, and we have got 2 webinars left, so which are going to be very different and very specific, and which is very, very in high demand, I would say, right now and all over the world. So next time we are going to speak about IP law vocabulary. So which is very interesting. And I think everyone is thrilled about the final final webinar that we're going to have on the 13th of April, which is going to be fintech law vocabulary, which is totally new for everyone, new zone, new area. And I know that I have talked to some students who have signed up for this project, and a lot of them were very interested in the final one. So we are building up the suspense.
Yes, and I think that they're both very interesting. Yes.
Yes, and we're really looking forward to. So we have already realized that from our experience that we do need some time for students to process the information, and they come up with the questions. I have already recited to Daniel at the beginning of our webinar today that we have some people who are actually making the list of questions, and I will forward them to Daniel. And then I suggest that you can, for example, choose out of the list to answer some of them because they are reflecting to the previous classes, and you can choose which ones are the most interesting. Okay, so we make sure that everyone is happy, and those who made a big job of writing these answers are also happy. Okay, so we'll do this. Thank you very much, Daniel.
Thank you, Sophia.
Yes, it was a great webinar today. So we're officially done with the language of contracts, and we have got 2 more webinars to go. And everyone excited about the test that is looming. I have been already asking me, do I have any samples on this? I said, no, not yet. So, but it will be very just nice, and everyone just shouldn't be afraid. It's just to refresh the vocabulary. Thank you very much, Daniel.
Fantastic. Well, thank you. And goodbye, everyone. Have fun.
Goodbye, everyone. And see you everyone, in 2 weeks on Wednesday of the 30th of March. And thank you very much, Daniel, for being with us. We appreciate it.
All right. Thank you so much. Bye-bye.